Well, the News Nation is also following the ongoing testimony in the George Zimmerman trial. On the stand right now, Florida Department Law Enforcement Crime Lab analyst Anthony Gorgone. And so far, he has been testifying about the DNA testing procedures. We continue to listen to that. Earlier, the prosecution was focusing on Zimmerman's prior knowledge about law enforcement procedures. And for the first time in this trial, Florida's controversial stand your ground law has taken center stage. Now, the testimony came after some early courtroom drama. The Zimmerman defense team objected to the prosecution bringing Zimmerman's prior education in criminal justice into evidence. After a 50-minute hearing, Judge Deborah Nelson ruled that the evidence was admissible. The prosecution then called Alexis Francisco Carter, a U.S. Army captain who was Zimmerman's teacher, for a local college class on criminal litigation. Take a listen.
Talk to me a little bit, Professor, about what kind of student you remember the defendant to be.
You know, you always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
Did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
When you taught the class, what is the core concept of self-defense when you can use deadly force?
When you have a reasonable apprehension of death or grievous bodily harm. And the term reasonable obviously has two components. So there's a subjective component, meaning that I feel like I'm in fear. In my mind, I feel like I'm in fear of death or grievous bodily harm. But when stuff hits the fan, you're judged by jurors.
Well, the prosecution also called two witnesses who testified to Zimmerman's interest in law enforcement, one saying Zimmerman applied for a police job in Virginia, the other showing paperwork from a ride-along that Zimmerman took with Sanford police back in 2010. Now, George Zimmerman has pleaded not guilty to second-degree murder charges in the shooting death of Trayvon Martin. He claimed self-defense. Martin was unarmed. Now, MSNBC's Craig Melvin is in Sanford, Florida, been there watching this entire case. Busy day of testimony. And Craig, I think the one that opened your eyes, all of our eyes, was when Judge Deborah Nelson brought up the possibility of the prosecution resting.
Yeah, you know, Judge Nelson, probably about 15 or 20 minutes ago, she indicated after a hearing that the state had basically told her that they had every intention of resting their case today. Shortly thereafter, Judge Nelson also said that she plans to go as long as it takes today to help the state do that. Of course, no court tomorrow here in Sanford, Florida, because of the July 4th holiday. Judge Nelson said that basically she expects the defense to be able to start their case on Friday. Judge Nelson also rejected a defense motion to adjourn until Friday. That's how we actually kind of got to know all of the stuff about the scheduling. She rejected a defense motion by Don West to adjourn until Friday. The defense wanted to adjourn so that they could depose two additional witnesses that they have not been able to depose yet. One of those witnesses is actually Benjamin Crump. Crump, of course, the Martin family attorney. Don West saying that he hasn't had an opportunity to depose him yet, wants to get that done. So again, the highlight right now, Richard, of course, this thing could be over for the defense at least today. Now, we should note here right now on the stand, Anthony Gorgone, the crime lab analyst. Of course, the prosecution has already introduced evidence that would indicate that there were no fingerprints found. There weren't Trayvon Martin's fingerprints found on George Zimmerman's 9mm gun. Right now, Gorgone is basically saying that there was no DNA evidence found on that gun as well. This is the 7th witness called today, the 33rd witness so far. But again, right now, the highlight, Judge Nelson, who is known for her punctuality, indicating that today could go a little bit longer than a lot of folks may have expected.
Craig Melvin, thank you so much for that. It certainly was an eye-opener. Joining us now, MSNBC legal analyst Lisa Bloom and criminal defense attorney John Burris. Lisa, to you first here on this. Was this part of strategy in some way to see how well prepared the defense was?
It could be. You know, that's the way these trials go sometimes. You know, you rest your case and all of a sudden the defense doesn't have a witness waiting out in the hallway and they don't look so good. It's not easy when you're a trial lawyer to have witnesses lined up waiting to testify. If they wait too long, they get annoyed with you. It can even infect their testimony. If they're not there when you need them, you get the judge annoyed with you. So it's not easy. When you add to that in this case that the defense has the right to take pre-trial depositions of witnesses before they testify, and they have not had the opportunity to do that with some of them, they're in a bit of a jam, and that hearing is going to continue where the judge will decide how to go forward.
John Burris, as you've been watching this, we have talked about how the Martin family is expected to be called to testify, as well as more forensic experts. We're seeing some of that right now. If they were to rest today, would they be able to fit all of that in with the time that we've got in front of us?
I think will be very challenging, particularly if you're going to put on the medical examiner, because that could take some time, although it's not in dispute. But there are aspects of the examination that may be, and that is the direction of the bullet. You might go to the question of what position they were in at the time the shooting took place. That could take some time. Of course, they're not going to want to spend a lot of time with the mom or the dad, because you don't want to go into that too much. They only want to really deal with the question of how certain could they be about hearing their son's voice. So it could be a challenge to try to get it all in. I would say it's not very likely, knowing how the examination of the defense has been, which has been very thorough and sometimes more exhaustive than necessary. To the extent that they need to play for time, they will play for time by extending the cross-examination. I would say only one additional thing here is that generally the prosecution is supposed to have told the defendant what witnesses are going to call next and have a series of those witnesses so that the defense is on notice. I'm surprised that they would be surprised that the case could end unless the prosecution decided that we've done enough. So it's still going to, there's some gamesmanship involved here. Having been in these positions many times before, I know lawyers are not necessarily candid with each other. They're really trying to get an edge any way they can.
And that's what's keeping our eyes there on Anthony Gorgone, the crime lab analyst, being questioned by the lead prosecutor, Bernie De La Rionda. Lisa, John, hang on one bit. We're going to continue and take it back to the courtroom there.
For one coin, 50% for the second coin, and you would get 25%, that they would both land on heads. This applies to the random match probability, the statistics I use, because these 13 or 15 locations that I test are all inherited independently. So once I determine the frequency that you would find the results at one of these locations in the population, I can then multiply it with the other 12 or the other 14 locations using this product rule to get a frequency that you would find that entire DNA profile.
In terms of some of the results that you're going to talk to this jury about, why are some of the results in terms of the numbers more than the actual population of the Earth, which I believe is now 6.5 or maybe 7 billion? Why is it higher?
I think it's almost 7 billion now, the population of the Earth. It really doesn't have anything to do with the population of the Earth. It's more about the frequency at which I see these results. It's similar to, if you think about it, sometimes you see it posted somewhere that the frequency or the probability of winning the lottery is 1 in a million. Well, that has nothing to do with how many people play the lottery or how many people live in the area. It just has to do is what is the probability that I'm going to match all 6 or 7 of these numbers and get them all right, based on what's the chance that a 1 is going to draw out versus a 44. It's the same concept with the DNA profiles. It doesn't matter how many people are on the Earth or in the Central Florida area or anything. It's just the probability based on how rare or frequent these results show up in these ethnic groups. It's the probability that this entire profile will be seen if you test a random individual.
And I believe the 3 ethnic groups or race groups you have is African American, Caucasian, and then you have what else? Hispanics, I guess, Southeast Hispanics?
For a long time, when we used the FBI database, we calculated the frequency of profiles for Caucasian, African American, and Southeastern Hispanics populations. Those are the 3 most prevalent in the Central Florida area. When we switched to the new database, when we're using our new system where we're testing 15 locations instead of 13, we do statistics for Caucasian, African American, and Hispanic, as opposed to Southeastern Hispanic.
All right, well, then let's talk about specifically what you did in this case, now that we've got the basic stuff out of the way. I believe you did 3 reports in this case, dated March 26, May the 9th and July the 26th of 2012, and it's under FDLE number 2012. The last four digits are 1890. Your reports and your entire file has been copied and previously provided to defense counsel. So with the court's permission, may Mr. Gorgillon refer to his report or notes at any time.
Any objections?
No.
Okay, thank you. Yes, you may do so.
It might be easy, Mr. Gorgillon, if we start off with the standards. I believe you received two standards or two samples that you did some DNA analysis, and specifically a swab that was represented as coming from the defendant, George Zimmerman, and then also a DNA card or blood card taken by the medical examiner from the victim in this case, Trayvon Martin. Do you recall that, sir?
Yes, that's correct.
Okay, all right. And what I want to do is first, with the court's permission, may I approach the witness, Your Honor?
You may.
Sir, I'm showing you State Exhibit 186. Now, I ask you if you recognize State Exhibit 186, sir.
The lead prosecutor there bringing another item to the fore for the witness to take a look at. We are going to take a short break here on MSNBC. We'll be right back with the George Zimmerman trial shortly.
With case number.